Yes, Your Honor.
They look okay?
Yes.
How about you, Mr. Harper?
Yes, Your Honor.
Okay. Is there, let's, because I've only done this once or twice. So I think I'm gonna read. Closing arguments is 2.7, so that has to come before the 3s. It's just the way it works. So I'm gonna read 2.7, closing argument, then we'll start the jury instructions, then we'll pause, because I think if I do it the other way, although the other way makes more sense, the other way being start the jury instructions, and then when I tell them to stop, then read 2.7.
I can't remember how it was done last time, but it could be something along the lines of, you know, the attorneys are going to make their closing arguments, but first I want to read you the instructions before so you can follow along the law and their arguments.
I meant to check one jury instruction because they have their cell phones. In Okaloosa, they keep their cell phones and they go to lunch. I need to look at one thing on the Florida Supreme Court website. Give me 1 second. I meant to check it. It's submitting case to jury. I took the paragraph out about cell phones, and I just want to make sure I did it correctly.
I thought they took,
Yes.
y'all take them out.
Remove the cell phone from.
Yes, sir. When they're deliberating, we remove them from the.
I know. I want to make sure that I did the instruction right though. In submitting case to jury. I heard that you guys take them when they start to deliberate.
Yes.
So let me just look. You know, now that all these are printed and they're fantastic. Whew. I'm making a face. When Judge Clark told me that they didn't have their cell phones in the courtroom, I just automatically popped the paragraph out about cell phones. But if you look at it, I popped it up on the screen for you. It says, it's the third paragraph down. Many of you have had cell phones, tablets, electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of devices into the jury room. Kindly leave these devices in your seats. Do you want me, that doesn't really apply, so I think we're okay. Do the judges ever read that paragraph, or do you just, I'm getting no's from the deputies. So the deputies they've got their system, they just take them away.
Correct.
I
They
think
can
that will address that. They will have it regardless.
I know Judge Clark will verbally state, I don't know about the instruction, but she'll state that the deputies will gather all the cell phones, smartwatches, tablets, and bring them to the courtroom for safekeeping while they deliberate, and then they'll be returned after.
That's what we did last time.
Okay, so what I can do is just when right before, and I should ask this question procedurally also. When they've reached because I give them a bunch of these little instructions, what do I do when I reach a verdict? You're gonna fold it in half, you're gonna knock on the door, let the court deputy know, please don't ask any of the bailiffs any questions, they can't answer questions, you've got your pencils and your pads. I do that conversation. I can simply say, when you go back to begin deliberating, they will remove your cell phones because the law does not permit you to have your cell phones during deliberations.
State has no objection.
That's fine.
Does that solve it?
Yes.
Okay, then the jury instructions are good as is. Okay, I'm gonna put that here to remind me. Okay, then we should be good. Anything that the state needs to take up before we bring in the jury?
No, Your Honor.
Mr. Harper.
Sorry, I apologize. I keep speaking on nothing for the defense.
It's okay. All right, let's bring in the jury. Thank you for your patience with me. I think what I'm going to do is say both the state and the defendant have now rested their case. Then I'll go into the jury instructions, and then right before you start, I'll do the attorneys will now present and split 2.7. State, is that good with you?
It's fine.
How about you?
That's fine.
Thank you, Mr. Harper. Okay, Do you want, does she usually hand them out, or I hand them to you and then you hand them out?
She should hand them out. Please stand for the jury.
Thank you, everyone. Please be seated. Okay, ladies and gentlemen, we are passing out the jury instructions. However, please do not read ahead, okay? When we get to the jury instructions, you are free to follow along or sit and listen, but again, please don't look ahead. Okay. All right. Did I do okay on time? You guys are still with me? We did as fast as we could. All right, you're still smiling. That's a good sign. Ladies and gentlemen, both the state and the defendant have now rested their case. We are going to turn to the jury instructions. As I mentioned, you are free to follow along or just sit and listen. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Brittany Nicole Chinchar, the defendant in this case, has been accused of the crimes of possession of fentanyl and trafficking in methamphetamine, 14 grams or more, but less than 28 grams. Count 1, possession of a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following 2 elements beyond a reasonable doubt. 1, Brittany Chinchar possessed a substance, and 2, the substance was fentanyl. To prove Brittany Chinchar possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Brittany Chinchar had direct personal power to control the substance or the present ability to direct its control by another. Count 2, trafficking in methamphetamine. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following 3 elements beyond a reasonable doubt. 1, Brittany Chinchar knowingly possessed a substance. 2, the substance was methamphetamine. And 3, the methamphetamine weighed 14 grams or more, but less than 28 grams. To prove Brittany Chinchar knowingly possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over the substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Brittany Chinchar had direct personal power to control the substance or the present ability to direct its control by another. If you find the defendant guilty of trafficking in methamphetamine, you must further determine by your verdict whether the state has further proved beyond a reasonable doubt that the methamphetamine weighed 14 grams or more, but less than 28 grams. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven, Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of trafficking in methamphetamine are possession of methamphetamine with intent to deliver and possession of methamphetamine. Possession with intent to deliver a controlled substance. Certain drugs and chemical substances are by law known as a controlled substance. Methamphetamine is a controlled substance. To prove the crime of possession with the intent to deliver methamphetamine, the state must prove the following 3 elements beyond a reasonable doubt. 1, Brittany Chinchar possessed with intent to deliver a certain substance. 2, the substance was methamphetamine. And 3, Brittany Chinchar had knowledge of the presence of the substance. Deliver or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. To prove Brittany Chinchar possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over the substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Brittany Chinchar had direct personal power to control the substance or the present ability to direct its control by another. Possession of a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following 2 elements beyond a reasonable doubt. 1, Brittany Chinchar possessed a substance, and 2, the substance was methamphetamine. To prove Brittany Chinchar possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Brittany Chinchar had direct personal power to control the substance or the present ability to direct its control by another. So I'm going to ask you to stop right there with your instructions, because I am now going to read you another instruction. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So the attorneys will give their closing arguments now, and then we'll read the final instructions. Okay? Thank you. Mr. Sprouse?
Thank you, Judge. May I have the technology?
You
pulled
may.
up?
You have control.
Forgive me. Trying to figure out why there's an error on there.
Close the error on
It happened during one of the videos.
Can you move it down? I don't know.
Will it let you exit?
No, it won't. I tried to task it because that doesn't run there.
Okay.
You can see through it.
Yeah.
Nothing's perfect, is it? We don't have perfect cases. We don't have perfect technology. But we have spent all day and the majority yesterday talking about this case. And I'm going to try to bring it in for a landing. So as we know, what Ms. Chinchar is charged with is possession of fentanyl and trafficking methamphetamine, 14 grams or more, no less than 20. These are the key people that you heard from. You didn't hear from the defendant other than from when she was actually at the incident, right? We saw a body cam of her statements. But you did hear today statements from Deputy Zellers, Deputy Miller, Deputy Reinhardt. And you saw their body camera. You heard from Ms. Jessica Bossler, who received the evidence from Okaloosa County Sheriff's Office and performed a litany of tests on those substances to confirm, for one, the presence of controlled substance and the weight of the methamphetamine. You heard about the traffic stop. There's no argument about the traffic stop. You heard about the canine alerting on the passenger side of the vehicle where Ms. Chinchar was seated. And you heard what was located in the bag, the floral colored bag that you can see on the video. And of course, we talked about what was in the bag. Essentially, necessities. You saw hairspray, you saw tampons, you saw Ms. Chinchar's methamphetamine and fentanyl. And that's clear by her actions and her statements. Right? As soon as she gets out of the car, she is trying to distance herself from that vehicle because she knows what's in that vehicle. Deputies say, you're not free to leave. Next trick in the bag. Can I get a tampon? Well, that's a reasonable request, I would say. On the side of the road, that's less reasonable. However, when the deputies say, you can't go back in that vehicle, you're not allowed to get what you're asking for, but we will definitely provide you one. You need it, we're going to get you one. Where are they at? And she says, I don't know where they're at. And here, Deputy Reinhardt's a question like this. There's something fishy, but why do you not know where they're at, given the statements that you just said? And then, eventually she's like, okay, they're in first they were on the floor, then they were in the back seat, and then they were in the bed of the truck. But they weren't in the bed of the truck, in the yellow bag of clothes. And if you remember, the opening statements of the defense, like a bunch of people are moving, a bunch of people are using this truck to move to wherever they're moving. If somebody's moving, they're going to have their stuff with them, right? It's going to be at their feet, just like the bag that was at the feet of this Chinchar. She had her necessities. She had everything that she needed for the remainder of the night and for the weekend. You can see on this picture, this is before Deputy Zellers even manipulates the bag, before he even touches it. This is right when he moves the jacket that's like concealing this bag. That's an open bag at the feet of the defendant. To suggest that she doesn't know what's in the bag when it's open and it's at her feet is absurd. It is absurd to suggest that somebody else left a trafficking amount of methamphetamine and fentanyl in a truck and just left it there. When she was given, she keeps saying it's not Misty's bag, Whitney's bag, right? The officer says, Whitney who? It's something, Whitney something. Okay, yeah, she does have a last name of something. And then, well, Mr. Campbell, do you know who it is? See him shake his head. You also heard from Mr. Campbell some inconsistent statements. Right? He said that she brought a bag, a book bag, and he did not want to answer that on the stand. He did not want to say she brought a book bag. Asked him multiple times. He did not. He was not forthcoming to my questions. The judge went over the law with you. I won't belabor the point, but I just want to talk about knowledge. At the beginning of this trial, I said, we're going to be talking about knowledge. That's the only thing that's in dispute. We're not, I didn't hear any dispute about whether it is a controlled substance or whether it was actually the weight that FDLE says it is. We are arguing about knowledge. And what do we have for knowledge? Other than the obvious that has been beaten into the ground. We have these cards. When she's presented with these cards, it's not her name, it's not Whitney's name, it's just random possible credit or debit cards. She knows where those cards came from. She has seen those cards before. That's clear in her statements. So I know where that came from. Yeah, because it's in your bag. That's why you know where it came from. And as far as fentanyl, we have the report from Ms. Jessica Boston. Confirming her opinion of what that controlled substance is, or that, in this case, green powdered substance. Her opinion is that it's fentanyl. She ran a litany of tests, explained the test to you, talked about her training and experience on how she came to that opinion that she had. Here we're still arguing about knowledge. Okay? That's the state's position, is that she knew what was in that bag. She doesn't have to own what's in that bag. That's not what the judge just instructed you on. It's not ownership of a controlled substance. It's possession of a controlled substance, knowing possession. And the state submits that. If you look at the evidence in the totality of the circumstances, what was in the bag, the statements about the bag, we know that you will find Ms. Chinchar guilty as charged, guilty of possession of fentanyl and guilty of trafficking methamphetamine 28 grams or more, or 14 grams or more, but less than 28. And I want to talk about the lesser included crimes that are under count 2. So you have sale, manufacture, deliver. This is just, we're saying, it is delivery, possession with the intent to deliver. That's what one of the lesser included offenses are. And I'll tell you why that's not appropriate. Possession with the intent to deliver is what we call a specific intent crime. So I would have to show her intent to deliver this substance or these substances to somebody else. Well, why that's not applicable is because we actually have a weight. In Florida, we prove trafficking by weight, and that's what we have. You saw the report, and the report can go back with you when you deliver it. But we have a weight. It's more than 14 grams. It is undisputed that there were over 14 grams of methamphetamine in that bag. In one of the bags that she had, you saw written on it, it was a 15, right? But it's undisputed that there's a trafficking amount. You're not going on intent to deliver. The proper verdict is guilty of trafficking in methamphetamine and guilty of possession of fentanyl. Thank you.
Mr. Harper?
Thank you. May it please the court, counsel. This case is about a bag. The contents of that bag. At the feet of my client in a truck where she was a passenger. A vehicle that you've heard testimony here today. Multiple people have been in and out of this vehicle, driving back and forth, moving their own personal belongings. You're going to have access to the body cams. It's going to go back with you. You can see her in the body cams, what she says, what she asks for. Watch it again. Watch it again and watch her go to the back of the truck where her stuff is. She's addressing an urgent personal matter, and that's where she goes. She made a big deal about it. She brought it up to everyone's attention. Urgent, and that's where she went. Repeatedly, Corporal Zellos asks her and tries to get her to make statements about the bag. Repeatedly, it's not her bag. She says that over and over again. At no point does she talk about like, yeah, that's my bag. It's always, it's not my bag, it belongs to Whitney. That's what it's about. The state's case is because she was in proximity to this bag and that there were tampons in this bag, that bag must be hers and that the contents of that bag are known to her. That's basically what Corporal Zeller said on the stand. He said that. I asked him flatly that question. And that's what he said. But that's not proof. That's not proof. Certainly not proof beyond a reasonable doubt. She never agrees that it's her bag. She never affirmatively states anything about knowledge or awareness of that bag and its contents. In fact, when it comes to the issue of her personal belongings, she is at the back of the truck. She was not the only person in that truck. She was not even the only female in that truck that day. We started this off by saying that we hold the state to prove this case beyond a reasonable doubt. That is their obligation, that is their duty. It's their responsibility. They have to prove that she knew about that bag, and more importantly, what was in the bag. What evidence was introduced today that showed that she knew what was in the bag? If we're getting down to the nitty-gritty of things, what evidence shows that she knew about the contents of the bag? Remember the officer's testimony. And again, please review the body cam. Other than the fact that she entered into a truck which already had bags in it and sat next to a bag, where was the actual evidence of knowledge of the contents of that particular bag? Mere proximity is not enough. It's in the jury instructions. What proof of knowledge was introduced today? They have to prove it. Now we circle back to the tampons. The state wants you to believe that this woman asking for a tampon looked through her own personal stuff from the back of the truck, didn't find a tampon. Gets the nerve, like, I have to take care of this, asked for napkins. You heard the deputy She wiped herself of her period blood on the side of a road. That is how urgent it was for tampons. But the state wants you to believe that the tampons in the front of a bag that she had no knowledge of was hers. Now, we started off this case talking about evidence, and it's not CSI, but there are no fingerprints in this case. Not of these baggies, not of the tampons. What knowledge have they introduced about awareness of the contents of that bag today that we've heard? Not what the attorneys say, not me, not the state. What evidence have you heard or seen that she knew anything about that? We're back to proof. The state doesn't get a free slide. No runs batted in. They have to, they must prove it. They have to do that. I started off by saying I don't have to say nothing. I said that in voir dire. I don't have to do anything. They have to prove it all. And the proof must be beyond a reasonable doubt. But what we've got here, tying her to this case, is tampons. My client entered a plea of not guilty because the bag is not hers, the drugs are not hers, those stupid tampons are not hers. And the state has not proven it. What evidence has they proved that she knew about these drugs in that particular bag? They have to prove each and every element. It'll be in the instructions that the judge is going to give you. They have to prove each and every element, beyond a reasonable doubt, that she had knowledge and exercised control. What proof have they provided today? They have not. Where was the knowledge? I'm asking you to use your common sense. Hold the state accountable to their duty. They have not proven this case. This is not a case that's decided on sympathy. Or like, oh, well, cops are here, it must be hers. We started off that way, saying that that's not the standard. It can't just be tampons tying this woman. She's not the only woman in the world. I ask you to find my client not guilty. Thank you.
State's rebuttal?
Yes, Your Honor. Ladies and gentlemen, it has to be a reasonable doubt. And that's the question that you're going to go back and deliberate and pick a foreperson. You will discuss whether the defense has, whether there's a reasonable doubt. Is it reasonable to ask to leave a traffic stop? Is it reasonable to ask for feminine hygiene products on the side of the road? And then when you realize you're not going to be able to get into that vehicle now you don't have those things. These are statements made by the defendant. You have the tampons, but then you have the statements that just don't make any sense. She knew that there were drugs in that bag. That's why she didn't tell those cops to go in that bag and look for the tampons. They would have found a trafficking amount of methamphetamine. So ask yourself, why did she make those statements? Why? The defendant exercised control over that bag. It's at her feet. It's clear that somebody was manipulating that bag. The state asserts that it's her. How long was she in that vehicle? Well, they went to the AOC and the Chevron. Because not just proximity, she has opportunity. She has knowledge of items that are in that bag. The state feels that we have proven our case beyond any conclusion of reasonable doubt. I want you to think back upon this story that the defense is saying, that they're moving. When you move, you take your things. It turns out what Ms. Chinchar's things are is hygiene products and trafficking amount of methamphetamine and a little bit of fentanyl. So those are what's necessary for her move, right? She's moving her valuables. And she's got it at her feet. Not in the back of the truck. That's not where you put your valuables. All that was in the back of the truck from the evidence, there's like a pair of pants. I don't even think there were 2 boots. I think it was like 1 boot in there. Those are not your valuables. That is not your entirety of your life that you're moving. You're going to take a bag, and it's going to be right next to you. That's what you care about. These are your things. We're asking you to use your common sense. We think it's a clear case. We thank you for your patience and your attention and your time. And we ask you to find the defendant guilty as charged. Thank you.
Okay, ladies and gentlemen, back to your jury instructions. We're going to turn the page, and you'll find plea of not guilty, reasonable doubt, and burden of proof at the top. All right, here we go. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Does the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to, whether, when the defendant made the statement, she had been threatened to get her to make the statement, and whether anyone had promised her anything to get her to make the statement. If you conclude the defendant's statement, if you conclude the defendant's made the I think there's a misprint there. If you conclude the defendant made the out of court statement, I am so sorry, but it was not freely and voluntarily made, you should disregard it. All right. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of witnesses and have seen in the form of exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job, and I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I have the only verdict form up here with me. so that we don't send back multiple verdict forms and we don't get the wrong one back. So it is one verdict form, and it will go back with you. It reads as follows. In the Circuit Court of the First Judicial Circuit, in and for Okaloosa County, Florida, State of Florida plaintiff versus Brittany Nicole Chinchar, defendant. Clerk number 2024 CF 423. Verdict. We, the jury, find as follows as to the counts charged. Count 1. You have two choices. Please choose only one. Guilty of possession of fentanyl as charged in the information, or not guilty. Count 2. You have 4 choices. 1, 2, 3, 4. Please choose only one. Guilty of trafficking in methamphetamine, 14 grams or more, but less than 28 grams, as charged in the information, or guilty of possession of methamphetamine with intent to deliver, a lesser included offense, or guilty of possession of methamphetamine, a lesser included offense, or not guilty. It then says, so say we all this 8th day of July, 2025. It is the 8th of July. It is the 8th of July. And there's a place for the foreperson to sign and print his or her name. So we'll send that back to you when we send the evidence back. Thank you. All right, back to the last page of jury instructions. Single defendant, multiple counts. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about the case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in the case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. Some of the exhibits will be sent into the jury room when you begin to deliberate. If you wish to see any exhibits not sent back, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Any objections or corrections to the jury instructions state?
No, Your Honor.
Defense?
No, Your Honor.
All right. I will sign and date them and hand them to the clerk of court to be filed. Thank you. All right. Ladies and gentlemen of the jury, are you all feeling well, ready, willing, and able to go into the jury room?
Yes.
Yes, fantastic. The reason I ask is one of you is our alternate. Who is Miss Moore? Hi, Miss Moore.
Hello.
You are our lucky. For the rest of you, when she returns, I'll send you out to begin deliberations. A couple of things. The bailiffs cannot answer questions. You have notepads, you can take your notepads with you, you can take your jury instructions with you, you can write a question. But your jury packets and instructions, you can take them with you and refer to them if you have a question. If you'd like to see any of the exhibits that were not sent back with you, just let us know. We'll get them to you, okay? When you have reached a verdict, fold it in half and knock on the door, and we'll gather here in the courtroom, okay? You have a video player back there. The videos will be sent back. And I think that is it. Did I miss anything? Oh, you cannot have your cell phones. Those can go back. Yeah, just those three, I think, that we decided.
Yes, the CD and FDR reports.
Yes. And there was a thumb drive also.
Yes.
Oh, you got it. Ladies and gentlemen, I know you've had your cell phones with you and you've been able to go, off campus for lunch, but during deliberations, the law does not permit you to have your cell phones. So the deputies are going to collect your cell phones and guard them, and then they will be returned to you when you have finished deliberating, okay? Anything I missed, Mr. Sprouse?
No, Your Honor.
Mr. Harper? All right, then our 6 jurors may begin deliberations.
Stand for the jury.
All right, thank you. Please be seated. So, Ms. Moore, you may be extremely happy that you get to head out of here at 3:28, or you may be frustrated that you don't get to go back and deliberate. You're like, I'm out. For obvious reasons, we're not allowed to tell the alternate who they are. Some people might not pay attention. You all were fantastic in staying awake and paying attention. The last thing that I always do, I'm just holding you captive right now to say thank you. That's really all I'm doing. The last thing that I always tell jurors is if you should ever see the attorneys in a grocery store or in a restaurant, they're never going to approach you and talk to you. They're not allowed to. But if you want to pick up the phone and give them a call and constructive criticism or ask questions, I know when I was a trial attorney, it was like gold to get to talk to a juror. No obligation, just giving you information. I always reintroduce the attorneys at the end of the trial. Mr. Cody Sprouse works for your elected state attorney, Ms. Ginger Bowden-Madden, and Mr. Rudy Harper works for Regional Conflict Counsel. Is that still Ms. Brower, Candace Brower?
Yes, Your Honor.
Okay, so I used to be able to say you could find them in the blue pages of a phone book, but I haven't seen a phone book in about 15 years. These two probably don't even know what a phone book is. But you can find them on the World Wide Web at whatever browser you use. Anyway, I just like to reintroduce them. And I just wanted to say on behalf of all of the court personnel, thank you for your service. And we're going to get you out of here.
Yes, ma'am, we can take it right now.
Okay, we're going to help get you out of here.
All right.
Okay,
I'm assuming to the front.
however you want to, however.
Sure, let's come right here.
Thank you. All right, on behalf of the state, is there anything that you need to take up before we are on break?
No, Your Honor.
All right, Mr.